Your knowledge of contract language is imperative.
You must know what a violation looks like if you wish to be active in its cessation.
It is important to understand that being active and knowledgeable affects your overall bargaining strength.
Together we can forge a more militant NALC.
Good morning, and welcome back to Parcels of Knowledge, that podcast dedicated to delivering knowledge to the city letter carrier with your host, the Roseville Wrecking Ball. All right, so today we're going to continue with the final part of reading from the Rights of Stewards. It goes over more than just the rights of stewards, but we're going to be talking about the grievance process, and we're going to be talking about a union's right to information, and we're going to be talking about the wine garden rights. So, that being said, today's going to be jam-packed. Next episode's going to be about, it's going to be actually for Roseville. You guys can tune in if you want, but it'll be my end-of-the-year recap for Roseville. What we've done for the year, essentially, this is something I normally do every year in the form of a letter. We're going to be doing a podcast this time. And, you know, I feel kind of weird posting it in a public forum, but I think, you know, maybe unions can learn from it. Maybe someone else can take what I do and make it their own, or maybe someone has criticism. Maybe they can tell me how I can do it better. So I think that's part of the reason why I'd like to do it like this. So, without further ado, let's get straight into the fun stuff. We're going to be talking about, first, the grievance process. Each section we're going to talk, and then we're going to read some questions. So, first, we're going to be talking about the grievance process. Several legal tenets guarantee the integrity of the grievance process. Filing. The National Labor Relations Act protects employees who file grievances in good faith. Management may not threaten, abuse, or harass a grievant, even if a claim is erroneous or unfounded. For example, management violates the Labor Act if a supervisor uses harsh language to intimidate a grievant, asks a grievant to stay away from the steward, tells a grievant, if you're unhappy, why don't you look for a job somewhere else, asks a grievant to withdraw a grievance, and repeatedly tells a grievant that the union is giving poor advice. Supervisors sometimes warn stewards not to solicit grievances. According to their thinking, a steward must wait until a worker comes to him or her with a complaint. The law disagrees. As stated by the board, solicitation of grievances is protected activity for stewards as well as other employees. Stewards can ask members to file a grievance or to authorize the union to file for them. Stewards also have protected rights to investigate grievances, including the right to request information and interview witnesses. Absent threats or intimidation, a steward cannot be disciplined for upsetting or harassing a witness. The Labor Act does not guarantee stewards a right to stop work to solicit or investigate grievances, except when this privilege is secured in the contract or by consistent past practice. Management may restrict active union business to breaks, meal periods, and other off-duty time. Settlement. Unions can resolve grievances on terms they deem proper, even if a grievant would prefer to hold out for better offer or take the case to arbitration. As long as the settlement is based on strengths or weaknesses of the case and is not influenced by animosity toward the grievant, the union cannot be charged with failing to provide fair representation. See, that's what I'm talking about in the last episode. The following rules are applicable. Management may not offer a settlement to a grievant outside the presence of the union. If the union requests, the employer must put the settlement agreement in writing and sign it. A union can withdraw a grievance because it lacks merit or for tactical reasons. To preserve its rights to file if a similar matter arises in the future, the union should state in writing that the withdrawal is without prejudice or precedent. Support. A union can use the following tactics to support a grievance, unless the contract clearly prohibits the activity or the activity disrupts operations. Handbills, petitions, rallies, buttons and T-shirts, letters to owners, letters to customers or clients, press releases, picket lines, and walk-ins, delegations to boss's office during non-work time. All right, questions and answer. Question, is the grievant protected if he engages in brash conduct during a grievance meeting? Answer, yes, although not to the same extent as a steward. In one case, the board voided discipline of a grievant who called the supervisor's arguments bullshit during the grievance discussion. Question, the day after the worker filed a grievance, her supervisor angrily asked, what's the big idea of calling in the union? ULP? Answer, yes, the statement is coercive because it deters the employee from engaging in union activity. Question, a manager said she plans to suspend a worker. When I said the union would grieve, she said, then I might as well fire him. If she does, will we have a ULP claim? Answer, yes, increasing a penalty because the union files or threatens to file a grievance is an unfair labor practice. Question, a supervisor told a grievant that she would get a better deal if she met privately with the hospital director. Are their remarks lawful? Answer, no, they interfere with the worker's right to be represented by the union. Question, management disregarded seniority in filling a vacancy, Should I file a ULP charge in addition to a grievance? Answer, no. Contract violations are not NLRA infractions unless the breach is so widespread that it amounts to repudiation of the union-employer bargaining relationship. Question, can a supervisor ask workers if they agree with a grievance that I filed? Answer, no. Canvassing workers to gauge support for a grievance violates the duty to bargain in good faith. Advise members not to answer. Question, a worker spoke with a steward immediately after an accident. Can management order the steward to reveal what she said? Answer, no. According to the board, consultation between an employee, potentially subject to discipline, and his union steward constitutes protected activity in one of its purest forms. To allow the employer to compel the disclosure of this type of information under threat of discipline manifestly restrains the employees in their willingness to candidly discuss matters with their chosen statutory representatives. Question, a supervisor saw a worker talking with his steward. When the supervisor asked the worker what he was talking about, the worker said union business. Can the supervisor make the worker review the particular topic? Answer, no. Asking for details of a conversation with a steward discourages employees from talking freely to their representatives. Question, an arbitration is scheduled for next week. If the company calls in a union witness the day before to ask questions about the case, can the witness refuse to answer? Answer, hard to say. In one case, the NLRB ruled that a union member cannot be forced to answer questions about a case that is scheduled for arbitration, but the decision was reversed by the D.C. Circuit Court. Question, a worker told management that a co-employee left work early without permission. Can we fine the worker for getting the fellow union member in trouble? Answer, this depends. A union can fine, suspend, or expel a member who informs on a co-member if the union constitution or bylaws forbid a member from causing harm to others. The NLRA prohibits a penalty. However, if the member is a lead person or supervisor with an obligation to report wrongdoing, or the information concerns a matter that the contract or company rule requires employees to report, or the member provided the information in response to a direct inquiry from management. Note, penalizing a complainant or informer may undercut the union's ability to make management reveal the names of witnesses in future cases. Question, when I gave my supervisor a grievance, he said it was worthless and tore it up. Can I file a ULP? Yes, destroying grievance papers in a hostile manner violates Section 8A1 of the NLRA. Question, our Human Relations Director is trying to destroy the grievance procedure. She has taken away the ability of supervisors to settle at Step 1 and she rejects every grievance at step 2. We think she is trying to bankrupt the union by making us arbitrate every case. Any suggestions? Answer. One response is group pressure, such as buttons, petitions, and rallies. You might also try ULP charge. A lengthy history of automatic rejections may be ruled bad faith bargaining. Question. Can management refuse to attend a grievance meeting unless the union allows it to tape the discussion? Answer. No. Recording a grievance meeting is a permissive subject of bargaining. Neither side may insist on the procedure. All right, so we're going to go straight into unions' right to information. The National Labor Relations Act requires employers to furnish unions with information needed to investigate, evaluate, and present grievances. Information must also be provided for contract negotiations, mid-term bargaining, and other matters relating to union representational responsibilities. The obligation to provide information is part of the duty to bargain in good faith. Refusals and unreasonable delays violate Section 8A5 of the Act. Unions can request information at any point in the contract administration process. This includes requests needed to monitor whether the employee is obeying the contract, the employer, investigate a complaint by an employee, decide whether to file a grievance or move it to a higher step, prepare for an arbitration hearing, and information can be requested orally. It is better, however, to mail or email the request or attach it to a grievance. It is good practice to request information each time you file a grievance. Some unions allow stewards to initiate the process. Others limit authority to officers or business agents. For us, obviously, as I've gone over before, the steward at the local level is in charge of requesting information, but that doesn't prohibit others to request it as well at the higher levels. The duty to supply information applies to records or facts that are relevant to contract administration or other union responsibilities. Information is relevant if it bears on the issues involved or could lead to identification of useful data. The union is entitled to information that both supports and weakens its position on a matter. Subject matter. When a union asks for information about bargaining unit members, relevance is presumed, and the union does not have to explain its reasons unless the employer raises credible objection. If the request concerns a matter outside of the bargaining unit, for example, the disciplinary record of a supervisor or correspondence with a subcontractor, the employer can insist on a brief explanation of why the information is needed. Specificity. Information requests must be reasonably specific. A request for all documents that support the company's position meets the test. A request for all information relevant to this grievance is too broad. Good faith. Information requests must be made in good faith. A request whose only purpose is to harass the employer can be refused. The employer's duty to disclose includes documents, data, and facts. If the union asks for a relevant document held by a related business entity such as a contractor, a parent corporation, or a subsidiary, the employer must attempt to obtain the matter for the union. The union can request lists, statistics, or other data related to a matter being investigated. Examples: the names of employees previously disciplined for the same infraction, promotions broken down by race and sex, all jobs subcontracted from the bargaining unit, chemicals used in the workplace, instances which a practice was or was not followed. Requests can go back several years, as many as 10 when investigating a past practice. A union can seek factual information needed to evaluate or present a grievance. Examples: describe the alleged misconduct in detail. Identify all persons interviewed. Provide all reasons for your decision. Please explain why you gave lesser penalties to the employees listed below. In discussions with the union about this grievance, you stated that management took similar actions without union objections on several prior occasions. Please identify each occasion referred to, including the date, supervisor, and employee involved. For discipline, ask for the names of all employees who committed the same offense in the past years and the level of discipline applied. If management interviewed the grievant or any witnesses, ask for copies of the interview notes. For contract interpretation disputes, ask for all facts or occurrences that support the employer's position. Request the employer's bargaining notes from the session during which the disputed language was negotiated. Promotion dispute. Request the personnel files of the successful bidder as well as notes or reports evaluating the applicants. Dangerous substance dispute. Request a material safety data sheet supplied by the manufacturer, copies of any OSHA citations, studies concerning the substance, and any known illnesses or claims for workers' compensation. A union can request information about non-bargaining personnel, such as supervisors or office staff, if the information is potentially relevant to a unit grievance. Disparate treatment. The treatment of non-unit personnel is often relevant in unit discipline cases. A labor relations principle dictates that when a work rule applies within and without the bargaining unit, such as a ban on intoxication, an employer may not impose a substantially greater penalty on a unit member than it imposed on a non-unit member who committed the same offense. To investigate, the union may ask for the names of any non-unit personnel known to have violated this rule, an account of the infraction, and any discipline imposed. If the union has factual basis for believing that a supervisor took part in similar misconduct as the grievant, and the rule in question applies throughout the workplace, the union can ask to examine the supervisor's disciplinary record. Example, the U.S. Postal Service fired a union member for falsifying a medical report. To prove unequal discipline, the union sought disciplinary records for two supervisors known to have doctored reports, one to make himself appear more productive, the second to obtain leave. The Postal Service claimed that the records were irrelevant and that releasing them would violate the supervisor's privacy rights. The board ordered the records to be produced. Harassment. When grieving a supervisor for threatening, cursing at, or intimidating a bargaining unit member, ask how the employer investigated the matter, any disciplinary action or corrective actions taken, and any other charges of harassment against the supervisor. When grieving a supervisor for doing bargaining unit work, ask for the supervisor's job description, schedule, and time records. Now, I'm not going to go into the Q&A for this one. Oh, there's a little bit more. Let's see. This one's not relevant. I'm not going to go into the Q&A for this one because information requests are very thoroughly covered by the NALC. I just wanted to mention some of the good information. And I will be going into the last category that I'd like to read, and I'll do the Q&A for that before I wrap it up. So, wine garden rights. When managers, supervisors, and security personnel interrogate employees, there is always a danger that they will use coercive methods. In an attempt at deterrence, the U.S. Supreme Court promulgated safeguards known as the wine garden rights. During investigatory interviews, says the court, employees have a protected right to ask for a union representation and can refuse to answer questions until the request is honored. Unions should encourage members to exercise their wine garden rights. In addition to serving as a witness, a union steward or officer can give advice on how to answer questions, help an employee avoid fatal admissions, object to intimidating questions, or rise mitigating and extenuating circumstances. The right to union assistance only applies during investigatory interviews. An investigatory interview occurs when 1. An employer or agent asks questions, and 2. The employee has a reasonable fear of discipline or other penalties. It is immaterial that the interrogator tells the employee, "We are only interested in finding out what happened." Or in many cases, they might say, "Oh, it's just a discussion." Run-of-the-mill conversation. Not every discussion with management is an investigatory interview, even if questions are asked. For instance, a supervisor may call a worker to the office in order to give instructions, correct a work technique, or point out new procedures. The worker may be apprehensive, but because the likelihood of discipline is remote, the worker may not insist on a steward before participating. Routine discussions can change their character, however. If a supervisor bears down and begins to ask probing questions, the employee, sensing trouble, has a right to ask for representation. Note, if a supervisor firmly promises that no adverse action will be result from an employee's answers, and there are no reasonable grounds for disbelief, the employee does not have a right to union assistance. A supervisor calls a worker to the office to announce a warning or other discipline. Is there an investigatory interview? The NLRB says no, unless the supervisor begins to ask questions. Absent a contract provision requiring the union's presence, the worker cannot insist on representation. Medical examination. Routine medical and fitness evaluations are not investigatory interviews, but if management orders an employee to take drug or alcohol tests to further a disciplinary investigation, the worker must be allowed union assistance before and during the test. The following procedures apply during investigatory interviews. The request. The employee may request a union representative when the interview begins or at any time thereafter. The employee can specify any currently available union agent. The response. Following a Weingarten request, an investigator has three lawful options. Stop asking questions and call in the requested representative, discontinue the interview, or offer the employee a choice of A, continuing without the representative, or B, ending the interview. Violation. An investigator who denies or ignores a justified request for representation and continues asking questions without the employee voluntarily relinquishing their Weingarten rights commits an unfair labor practice. The employee cannot be charged with insubordination for refusing to answer. Steward rights. Employees sometimes assert that stewards must be silent during investigatory interviews, but under the law, a union representative must be allowed to give effective assistance and counsel. In particular, the steward can ask for specific charges being investigated. Management does not have to give away its entire case, but must provide at least a general description. For example, we have a concern that Linden might have been abusing company's sign-in policy. The steward can insist on private consultation or caucus with the employee before questioning begins. The steward can advise the employee on how to answer particular questions. The steward can take notes. The steward can object to harassing or confusing questions. However, the steward cannot repeatedly interrupt, abuse the interrogator, or attempt to turn the meeting into a debate. Management has a right to investigate misconduct, and employees have a duty to cooperate. The steward can point out extenuating and mitigating circumstances. If the interrogator refuses to reveal the matter being investigated or allow a private consultation, the steward can advise the employee not to answer. Weingarten rights are sometimes confused with Miranda rights. Under U.S. Supreme Court's Miranda decision, a police officer questioning a person in custody must explain the person's right to legal representation. Weingarten does not go this far. Employers have no duty to inform employees about their right to request union assistance. Unions should educate members about the value of representation. One technique is to distribute wallet-sized cards stating a request for union assistance. Members should be advised to present the card if they are called in for questioning. ULP charge. Requiring a worker to answer questions without representation, refusing to tell the representative the reason for the investigation, or refusing to allow a private caucus with the employer, telling the representative not to speak during a meeting violate Section 8A1 of the NLRA. The union can file a ULP charge even if the employee answers the employer's questions. The labor board usually does not defer Weingarten charges to the grievance arbitration process. All right, so finally we're on the final parts, question and answers. Question. A supervisor questioned an employee after a job accident. When the worker asked for union representation, the supervisor said, "If you insist on a steward, I will have to bring in labor relations. If we can keep it at this level, things will be better for you." Is this a violation? Yes. The boss is trying to coerce the employee into abandoning his Weingarten rights. Question. A foreman told the worker to report to human relations office for a talk about her attitude. When the worker asked to speak her steward first, the foreman said no. Can the worker refuse to go to the office? Answer: no. The worker must go to the office and repeat the request. Question: the company says the union contract gives up workers' Weingarten rights. Could this be true? Answer: only if the contract expressly provides that the employer may conduct investigatory interviews outside the presence of union representation. Question: can a steward insist on a second private caucus while an employee is being questioned? Answer: the board has not ruled on this issue. Question: if management orders a worker to open her locker, can the worker refuse until she has a chance to consult with her steward? Answer: yes, unless the employer is conducting a general search of all lockers. Question: a boss called a worker at home to ask about an accident on the job. Did the worker have to answer the questions? Answer: not immediately. Weingarten applies to telephone calls. An employee who fears discipline can refuse to answer questions until he has a chance to consult with his union representation. Question: when management asks a steward to defend her own conduct, can the steward insist on union representation? Answer: yes. Stewards and officers have the same Weingarten rights as rank and filers. Note: when an employer interrogates a steward or other representative about union misconduct, it may only ask about the allegedly unprotected aspects of the steward's conduct, not its legitimate aspects. Question: if the manager unlawfully rejects a worker's request for union assistance, coaxes him into admitting guilt, and fires him, will the NLRB order the employee's reinstatement? Answer: probably not. The usual remedy for Weingarten violation is an order that the employer posts a knowledge acknowledging wrongdoing and promising not to repeat it. Make-whole relief may be ordered, however, if an employee is fired for engaging in subordination or dishonesty during the interviews. Question: if an employee is asked whether another worker violated a safety rule, can the employee assist on union assistance before answering? Answer: yes, if the worker has reasonable fear that her failure to report the incident could lead to punishment. She could be compelled to answer, however, if management unequivocally assures her that she will not suffer any harm from her answers. Question: a worker accused of fighting was told to write down everything that happened. Did the worker have a right to consult with a steward before putting that account together? Answer: yes, the request comes under Weingarten. Question: can a worker insist on postponing an interview because her steward is out sick? Answer: not if another union representative is available. Question: does an employee have a Weingarten right to consult a steward before carrying out an order that violates the contract? Answer: no, an order to perform work is not an investigatory interview. Question: can a worker be punished for refusing to answer or for making dishonest statements during a Weingarten interview? Answer: yes, unless an employer illegally refuses to honor its Weingarten obligations. An employee questioned about his conduct must answer in a truthful manner. All right, so that wraps it up for those three. Hopefully you guys found that interesting. I don't know if these reading of the steward rights is going well or if you guys think it's boring, but the good news is this is the last time I'm going to read from this book as far as I am concerned. So hopefully you learned something valuable today. And as always, have a good day.
Out to the Roseville Wrecking Ball. He is an Article 8 scholar, and thank God. We need Article 8 scholars right now. The Grievance Genius and the Roseville Wrecking Ball doing amazing work.
Brothers and sisters, this guy is good, man. He's fucking good.
And my boy Joshua, he killed it. Man, he's lockstep right now. He's killing it.
You would think this guy has been around for 30 fucking years. That's how good he is. Yeah, it's like he wrote the contract.